the ability to unmute. But I would ask you, please let us get through this meeting. I know it's very contentious and there's a lot of emotion going into tonight amongst some people. But let the board get through what they're going to get through. There will be time, not this evening, to go through and have everybody be heard through any action. So please just basically in kind of an observing capacity this evening, keep yourself muted unless you're a board of directors. Obviously, you're welcome to observe these proceedings, but we want to get it through the board business and be able to move on. I'm giving everyone just a few minutes to get logged in. Okay. Again, my name is Sarah Webner. I'm going to be chairing this meeting on behalf of the association. Do I have a motion to call to order Board of Directors meeting at 5:02? Motion to call. Seconded. Janelle, do you say? 3 seconds. Janelle, second, I heard? Yes. Okay. All in favor?
Aye. Aye.
Aye. Perfect. And just for the record, can I have my board members who are present just briefly just say hello, just announce your name?
DJ Johnson.
DJ, perfect.
Tom Franzen.
Thank you. Eric Tirado. Janelle Marazon.
Scott Davis.
Carlos muted. Carlos, are you here? He's there, but he's muted. I see him. Okay. Carlos, we see you in the chat when you get a moment. Just unmute and say. Parts of notice, I understand 48 hours posted notice was provided by the board of directors, saying date, time, location, and providing the Zoom information for proof of posting, an affidavit backup to substantiate the same to be provided. What we're here tonight, for anyone who's not aware, most of you probably are, there is a membership meeting to vote to recall 3 of your board of directors. So what does that mean? It now goes to the board to certify whether that was done correctly, because there's a lot of technical legal requirements that go into a recall.
Okay, here's where I'm going to jump in here. And first of all, say that Attorney Sarah Webner's improper role and conflict of interest is clearly shown here. Improper conduct as meeting chair. HOA attorney Sarah Webner chaired the meeting on May 1st, 2025. It was a certification meeting despite actively representing the interests of the recalled directors in their effort to invalidate the recall. This created a direct conflict of interest. An attorney advising directors under recall should not also serve as the neutral facilitator of a meeting designed to determine the validity of their own removal. No vote was taken to allow her to chair. No neutral party, such as the secretary, was designated. This caused a predetermined framing of the outcome. The entire meeting was conducted under the assumption that the recall would be rejected. The attorney never gave equal weight to the possibility of certification, nor explained that rejection would only be valid if based on statute-backed procedural grounds and non-conflicted board majority. Misstatement of the board's role at timestamp 2 minutes 49 seconds. At this mark in the May 1st meeting recording, Sarah Webner stated that it is the board's role to certify whether the recall was done correctly. This is a mischaracterization of the board's legal function under Florida Statute 720.303(10)(c). The statute requires the board to either certify the recall or file a petition by arbitration if they believe that the process was legally flawed. The board does not serve as the judge and jury over the recall's validity. Their role is administrative. Confirm whether the recall met procedural requirements, not whether it was subjectively valid.
For good reason. You don't want people thrown off the board without following proper procedure. So the board tonight can motion to reject the recall. That has to be done by a majority of the board, saying no, we don't believe that it was done correctly. Oh, Carlos, we can hear you. Is that you, Carlos? I think I heard him for a second. And if they are going to reject it, they have to provide specificity as to why. Now, then it is deemed rejected, but that's not where the story ends. If it's rejected, then within 5 business days, the association does have to file a petition with GDPR, having GDPR, the Department of Business, look over the rejection and make a determination as to whether or not it was a valid rejection or should the board have certified it. And they'll make that call. They'll sign an arbitrator who will review everything. It'll involve your owner's representative, Scott Davis, who will have a chance to provide all of the evidence to DBPR saying, here's why we think it should have been certified. The association will provide everything saying this is why we think it should have been rejected. Okay. So at this time, I'm going to ask for any of my board members, is there a motion to reject the recall?
Leading the board towards a predetermined outcome. At approximately 4:20 in the meeting, rather than opening the discussion by asking whether any board member wished to move to certify or reject the recall, Sarah Webner opened with, "Is there a motion to reject the recall?" This framing strongly implies that rejection was the expected and guided outcome. Given that she was also advising the recall directors, this direction further calls into question the neutrality of the proceeding. This framing, combined with Webner's dual role as legal counsel for the recalled directors, confirms the presence of bias and procedural impropriety throughout the May 1st certification meeting. When combined with Webner's dual role as legal counsel for the recalled directors, confirms the presence of bias and procedural impropriety. The entire meeting was conducted under the assumption that the recall would be rejected. The attorney never gave equal weight to the possibility of certification, nor explained that the rejection would only be valid if based on statute-backed procedural grounds and non-conflicted board majority, meaning the board having recalled directors voting on their own recall.
Motion to reject. Is that Erica? Yes. Okay, Erica, can you provide specifications in detail as to why the board is rejecting, knowing that this will go in the meeting minutes and then be provided to DBPR? Yes, so there's several reasons. One, the proxy did not contain the date, time, or location at the time of the signature.
At 4 minutes 45 seconds in the meeting, Erica Tirado falsely claimed that the proxy form did not state the date, time, or location of the meeting at the time of signature. She omitted the line printed on the proxy explicitly stating that the meeting date would be inserted by the proxy holder upon scheduling and in accordance with Florida Statute 720.306(8)b. Florida Administrative Code 61B-81.0031D requires the proxy to include the name, parcel, address, and the date of the proxy that was signed. There's no requirement that the meeting date, time, or location be present at the time of signature, especially when the proxy clearly states that the meeting details will be inserted once scheduled. The actual language on the proxy form reads, special meeting date inserted by proxy holder once scheduled. Meeting date to be inserted by proxy holder upon issuance of meeting notice. In accordance with Florida Statute 720.306(8)b. This explicit instruction fulfills all procedural requirements. Erica Tirado's statement ignored this section of the form entirely and misrepresented the legal standard. The statute and rule require intent, not pre-scheduled logistics. The proxy form complied in full.
For each owner, and after the signature, only a date was written in. The next reason is the proxy did not have a vote contained within it, meaning it didn't say for or against each director. It didn't have also whether they can say yes or no, if they can vote to keep or recall the owner. I'm sorry. I think Carlos's audio is finally working. He was just noisy. Go ahead, Erica. So the proxy did not state yes or no for someone to choose to vote. They just simply said recall off. The votes have to be separately or independently of each director. So it should not be linked to another director.
At 4 minutes 56 seconds, Tirado then stated that the proxy did not contain a vote contained within it. alleging that it failed to say yes or no for each director or give a choice to keep or recall them. This assertion ignores the statutory allowance for votes to be cast separately at the meeting by the proxy holder. This claim is partially accurate, but it does not invalidate the recall. The proxy form, as included in the DBPR package, did not include literal yes/no boxes per director on the form itself. However, the recall was conducted by a special meeting of the membership, and as the designated proxy holder, I cast individual votes for each director on the record as required by Florida Statute 720.30310C and Rule 61B-81.0033D. Florida Administrative Code 61B-81.0031B requires separate voting for each director, but this can be fulfilled during the meeting, provided the proxy holder casts individualized votes on behalf of those who assigned authority, which I did. The purpose of individual voting was achieved in full, with public vote counts announced and recorded for each recalled director. Therefore, while the form itself didn't include separate yes/no fields, the procedural requirement for individual voting was fulfilled lawfully through the proxy holder's in-meeting actions. Purpose of the meeting is to vote on the recall of 4 members of the board of directors in accordance with Florida Statute 720.30310. The directors subject to recall are Janelle Marazon, President; Erica Tirado, Treasurer; Tom Franzen, Director; Katie Monroe, Director. Katie Monroe has since resigned and notified both the board of directors and myself. Florida Statute 720.30310J requires a separate vote for each board member being recalled. We will now proceed with individual recall votes. As the proxy holder for 80 signed and dated proxies plus my own vote, I will now cast these votes separately per director. For the recall of Janelle Marazon, I cast 81 votes to recall, 0 to retain. For the recall of Erica Tirado, I cast 81 votes, 0 to retain. For the recall of Tom Franzen, I cast 81 votes to recall, 0 to retain. And for the recall of Katie Monroe, I cast 81 votes to recall, 0 to retain.
Also, the proxy said on the top, general proxy. However, it did contain a list, which would make it limited in scope with the list of items that it contained on the proxy.
The proxy form said general proxy, but it included a list, making it limited. She continued by criticizing the general proxy label while admitting the form contained specific recall content, contradicting her own argument. The label general proxy does not change the legal authority of the proxy itself. What matters under Florida law is the intent and scope of the proxy, not its title. This proxy was clearly created for a special meeting of the membership under Florida Statute 720.3061B, where the recall was conducted via in-person votes, including those cast by a designated proxy holder. This document authorized Scott Davis to vote at a specific meeting with enumerated items that included the recall of named directors. This clearly makes it a limited purpose proxy for a specific meeting. This was not a written recall agreement under 720.30310B, and it was not a generic proxy form for general board business. It was a meeting proxy for a special recall vote held under Florida Statute 720.30310C and Rule 61B-81.002. This objection misunderstands both the legal function and the actual content of the proxy form.
The statute 720.303C1 states that you can perform a recall in a meeting in lieu of an agreement in writing in the governing documents, however, specifically provide the members may only also recall and remove a board of directors to vote by a vote taken at a meeting. But the bylaws of the Surrey Ridge also say that the majority of the members may remove a director, but does not say it does not say at a meeting. Therefore, by written agreement would have not been done properly.
The bylaws only allow recall at a meeting, not by written agreement. At approximately 6:50 to 7:05, she cited Florida Statute 720.30310C1, implying incorrectly that the statute does not allow recall at a meeting and instead must be done by written agreement. This is directly false. 720.30310C explicitly governs recalls conducted via special meeting. This objection is irrelevant because the recall was not conducted by written agreement. It was executed through a properly noticed special meeting of the membership under Florida Statute 720.30310C. Homeowners either voted in person or submitted limited purpose proxies. As a proxy holder, I cast individual votes for each director as required by law. The bylaws are fully satisfied by this process, and this objection incorrectly applies standards from the written agreement recall process, which doesn't apply here.
Also, 720.03 that says that if vacancies occur during a meeting of a recall, then the majority would have to at that time select the replacement of those vacancies, and that did not occur as well.
No replacements were named during the meeting. This is a mischaracterization. Florida Administrative Code 61B-81.0031C requires a list of eligible and willing replacement candidates only when the recall is conducted by written agreement. This was not a written agreement. Since this was a special meeting of the membership conducted under Florida Statute 720.30310C, the procedure for replacement is different. If the board certifies the recall or the DBPR orders certification, the remaining directors may appoint replacements under 720.30310E, or an election may be called under 720.3069. There's no legal requirement that a slate of replacements be listed on a proxy form or voted on during the meeting when the recall is conducted at a membership meeting. This objection confuses written agreement recall procedure with special meeting recall procedure and is therefore invalid.
The next would be that there were 11 proxies that are rejected for several reasons. 3 of the owners revoked their proxies prior to the meeting, and 8 of them were present at the meeting, so that would void their proxies, and they did not vote. And they're as follows. So 9849 Surrey Ridge signed in, that was present at the meeting in person, and also turned in a proxy. So that one is rejected. The next one is 9842 Surrey Ridge. Same reason, signed in, was present at the meeting, and the proxy is invalid because they were present. 9902 Triple Crown, same reason, signed in. The proxy is invalid and did not cast a vote, for they were there present at the meeting. There is, I don't have an address on this one, but it has a name. DeLeon, Rosa, and Eileen signed in, also in person, and their valid is their proxy is invalid. They did not cast a vote while they were there. 2243 Churchill Downs Circle, signed in, was in person, proxy is invalid, and did not vote in the meeting. 9969 Triple Crown, signed in person, proxy invalid, did not vote during the meeting. 9954 Triple Crown, signed in, was in person, proxy is invalid, did not vote during the meeting. 9848 Surrey Ridge, signed in, the proxy is invalid, and did not vote while they were there.
Finally, at 7 minutes 5 seconds, she stated that 11 proxies were rejected without qualifying that this was her personal opinion, not a verified or board-approved finding, nor was there a motion or a vote specific to rejecting those individual votes. Of these, 8 were rejected based on the false and unsupported claim that if a homeowner submitted a valid proxy but later signed on to the meeting to observe, their proxy vote was automatically voided. This is incorrect and not supported by Florida law. Signing into a meeting as an observer does not revoke a proxy, and there was no evidence presented that these homeowners cast ballots in person or attempted to revoke their proxy in writing prior to the vote. Their attendance in no way invalidated the original proxies, and this reasoning directly contradicts both Florida Administrative Code 61B-81.0031K and Florida Statute 720.3068, which govern proxy validity and revocation procedures, without qualifying that this was her personal opinion, not a verified or board-approved finding, nor was there a motion to vote specific to rejecting those individual votes. We will now accept in-person votes for each board member individually. Please indicate your vote for or against the recall of each named director when called. and those are people that have not voted by a proxy. As you can tell by the video on April 25th at the homeowner-led recall meeting, the proxy votes were accepted and cast on my behalf, and I specifically called for no one to vote that had already cast a proxy to make sure that no one voted twice.
And the three that revoked were 2129 Churchill Down, rejected the proxy prior to the meeting. 2229 Churchill Downs revoked the proxy prior to the meeting. And 9979 Triple Crown revoked their proxy prior to the meeting.
No revocation forms were provided to the proxy holder or HOA secretary as required by Florida Administrative Code 61B-81.0031K. Revocations must be received before the recall is served on the board. These were not. The forms were allegedly collected by Morgan Property Solutions, a vendor with no authority to solicit or process recall forms, with a vested and financial interest in keeping the existing board of directors who supported his hiring, while it's publicly known that I did not. His termination is also on the proxy form as a limited list of items a majority voting interest homeowners supported. Forms lacked meeting details, proxy holder assignment, and were never disclosed to required parties prior to any votes being cast, nor at all, as I nor the Secretary Carlos Garcia have ever been presented with such forms to date. Therefore, all three alleged proxy revocations, which I've never seen and have never received from the HOA attorney, those revocations are invalid.
Okay. Understanding the reasons for the rejection and the motion, is there a second to Erica's motion?
I second Erica's motion.
Is that DJ?
Yes.
Okay. Now we're gonna go one by one and vote yes or no. So if you guys could just say your name and then yes or no, each director. Yay or nay, actually.
Tom Franzen, I vote yay.
To reject. Okay. Janelle Marazon, I vote yay. Erica, your vote, I assume, is yay. Yeah. You made the motion. Perfect. Yeah.
Recall directors voting on their own recall. At the May 1st, 2025 certification meeting, all three directors subject to the recall, Janelle Marazon, Erica Tirado, and Tom Franzen, voted on a motion to reject their own removal from office. This presents a direct conflict of interest as recognized in multiple DBPR arbitration rulings. Florida Administrative Code Rule 61B 81.003 does not prohibit directors from voting on their own recall, but when their votes are decisive, which was in this case, DBPR often considers the action invalid due to inherent self-interest. Without their votes, the motion to reject the recall would not have passed, and the recall would have been certified or defaulted into certification. This will be a central issue in arbitration, and such conduct undermines the legitimacy of the board's decision.
Okay.
DJ Johnson, yay.
Okay. Carlos, are you abstaining or would you like to cast?
This is Carlos Garcia, I'll abstain.
Abstain? Okay.
What is the exact question again?
There's a motion to reject the recall. So just agree or disagree with that. Yes or no?
I disagree now.
Okay. The motion does carry by majority board. So what happens now? That's what we talked about. I will be filing a petition with arbitration that will have the department look over the reasons that Erica cited, and they'll make a determination. They'll say, yes, we agree. It was proper. You should not have certified. Things weren't done according to statute. They may say, no, we disagree. We think you should have certified. And if the department thinks, no, everything was done correctly, they'll certify it, and then the recall will occur, and those three people will be off your board. So there's a lot of good oversight. It's an appeal. Some people tonight who maybe voted for the recall are saying, wait, I voted. We thought we had this vote. Know that DBPR diligently looked through this. Your owner's representative, Scott Davis, will be provided an opportunity We present that side of the argument to DBPR. They will receive copies of the proxies, copies of the video from the evening, copies of the owner roster. They really go through it. Typically, we'll even have 1 or 2 hearings with DBPR to really discuss these issues, get into it, and they'll make that determination. Did it follow statute, yes or no? And then we'd be announcing that to the community. So with that said, thank you all for being here. Do I have a motion to adjourn?
I have a question though. I'm one of the residents that was listed as being present at the meeting. That confuses me. I'm 9848 Surrey Ridge Road. Can you explain that to me?
Did you not attend the meeting?
I did attend the meeting.
Okay, so the way that a proxy works is you're sending someone on your behalf. If you're there, then you should have casted a ballot on your behalf. Now, the counter argument to that is you were just there to observe. And that's what I understand the other side is sort of saying about it. Like, hey, people gave me the ability to vote for them, but they wanted to come and see the proceedings. So both sides of that argument will be presented to DBPR for them to make a determination. But typically, when you go to an HOA meeting, a proxy is only used if you can't attend. You're sending someone in your place. But if you're there, it doesn't really make sense that there's you and a proxy holder there. It sort of like invalidates the two. So that's the argument on one side. There's an argument on another. We'll see what DBPR thinks about it.
At the end of the meeting here, Attorney Sarah Webner reiterated this falsehood, implying that homeowners who submitted proxies but also signed in to observe the meeting may have invalidated their votes, stating that typically a proxy is only used if you do not attend the meeting, and that signing in may void your proxy. This is a gross misrepresentation of Florida law. Simply signing a meeting sign-in sheet does not void a valid proxy unless a written revocation or in-person vote occurs. Her statement misled homeowners, some of whom were present to simply observe, not vote, and whose proxies were still valid and effective.
We will now accept in-person votes for each board member individually. Please indicate your vote for or against the recall of each named director when called. And those are people that have not voted by a proxy.
I'm honestly not sure if I'll vote for that.
I want to add at this point that before I sent out the meeting notice to homeowners, I consulted with legal counsel Sarah Webner, who's on the call now directing this meeting, and she stated specifically that this had to be an in-person vote. I tried to do it on Zoom. We printed over 100 mailers, and right at the last minute before she clocked out for the day, in came an email that said this has to be done in person. So we changed it and we made it in person.
In addition, I must address one final and critical point regarding the conduct of HOA attorney Sarah Webner. Prior to the May 1st meeting, Ms. Webner emailed me and stated that the recall vote had to be conducted in person, leading me in good faith to restructure the entire event. I complied. We canceled planned Zoom session, reprinted 145 physical notices, and held the meeting at the pool pavilion. To ensure transparency, I also hand-delivered the full compliance package to her office during rush hour traffic, including all proxies, affidavits, and meeting documentation, personally signed in by her assistant, Jackie Figueroa. Despite this, the attorney used my cooperation against the homeowners. The sign-in sheet submitted as part of compliance was used to invalidate proxy votes based on the false assertion that simply signing in voided their vote. When I asked about any revoked proxies just 2 days before the meeting, I was told none existed. 6 hours before the meeting, I was suddenly informed of 3. Even after repeated requests, neither I, as the proxy holder, or Carlos Garcia has ever been provided with a copy of these alleged revocation forms. These revocations were solicited by Morgan Property Solutions, a third-party vendor with a financial interest in protecting the current board. These forms lacked legal sufficiency and were never formally disclosed. What should have been a clear community-driven and legally sound recall was met instead with retaliation, procedural manipulation, including adding myself as an agenda item on their own board meeting to remove me, which failed, and misuse of the very compliance tools I submitted in good faith. Every single claim raised to reject the recall is procedurally defective, contrary to Florida law, or executed by conflicted individuals. A recall followed 720.30310 and Rule 61B-81.003, included proper proxies, signatures, and dates, was served lawfully with an affidavit of mailing. had been obstructed by recalled directors and an attorney acting with dual loyalty. This is not a legal defense. It's a power retention scheme funded by your dues. All rebuttals and documentation will be submitted to DBPR in full.